Okay, everybody, we're going to get started. I'm Lark Turner. I'm a 3L here. Thank you all so much for being here, and thanks to the Harvard Law Forum, the longest-running law school speaker series in the nation, for the pizza, and for sponsoring. It was difficult to talk Pete into bringing a practicing lawyer to campus, but I prevailed in the end. We're lucky today to hear from Joshua Matz, a lawyer at the forefront of what's been dubbed by the Twitterverse as the legal resistance to the Trump administration. After graduating from HLS in 2012, Joshua went on to clerk for Judge J. Paul Etkin of the Southern District of New York, the late great Judge Stephen Reinhart of the U.S. Court of Appeals for the Ninth Circuit, and Justice Anthony Kennedy of the U.S. Supreme Court. He's now of counsel at two great public interest-minded firms, Kaplan and Company and Gupta Wessler, and in the wake of the most recent election, which you all may remember, started publishing the Take Care blog, which seeks to ensure that the president shall take care that the laws be faithfully executed. With Professor Larry Tribe, who's here today. Thank you for coming, Professor Tribe. He's the author of Uncertain Justice, The Roberts Court and the Constitution, and the forthcoming book To End A Presidency, The Power of Impeachment. Joshua has been described by the leading legal snark blog Above the Law as a legal wunderkind. Is involved in too much constitutional and civil rights litigation to list in full. But his practice includes representing DC and Maryland in the Emoluments case that just survived a motion to dismiss last week, litigation challenging President Trump's appointment of Mick Mulvaney as acting director of the CFPB, taking on Mississippi's anti-LGBT religious freedom law, challenging Trump's travel ban, and representing a prisoner challenging the revocation of his informal pauperous status under the Prison Legal Litigation Reform Act. Without further ado, Joshua Matz.
Hi, so Lark has set the bar way too high. I'm here to just talk today a bit about some of the litigation that surrounded the Trump administration. I feel silly doing it because I see some people in this room who I think should be lecturing me on that topic, including Professor Tribe. But I will do my best. The election of 2016 was unprecedented in many respects. It was the first election ever involving two non-incumbents marked by open threats of impeachment for whoever won, which was probably in retrospect not a great sign. It was an election that led about half the country to view the candidate who ultimately won as fundamentally unqualified to hold the office. And it was an election that I think brought to a head some of the most disturbing trends in recent American democratic practice and dysfunction. And following that election, impeachment talk and talk about the threat that Trump posed to the nation only increased at an accelerating rate between Election Day and Inauguration Day. There was a widespread perception, I think correctly so, of chaos, illegality, and sketchy dealings in Trump's transition. And then on Trump's very first working day in office, he was sued by a group of lawyers, including me and Professor Tribe, for his violations of the Foreign and Domestic Emoluments Clause. That lawsuit was what turned out to be the first of a tsunami that has continued essentially without interruption from his very first day in the office of the presidency. And what I'd like to talk about today is what makes that trend, which has been broadly described as the legal resistance to Trump, unusual. Why do I think it occurred? Because, it's easy to take for granted, like he's there, we should sue him. But it turns out it doesn't always work that way. What these various resistance-styled suits are trying to achieve and how we might comprehend the judicial response to those suits thus far. And then at the end, I'll stop and take some questions. So just to put this in context, if you think back to the Obama administration, here's an 8-year period of time. I sat down and I tried to make a list of the constitutional suits against the administration that, for lack of a better term, mattered, right? The ones that you'd read about in the papers, that you would get taught in classes here at Harvard. And here's what I came up with. Challenges to Don't Ask, Don't Tell, and to the Defense of Marriage Act, which were not really Obama administration policies and which the administration all but ran away from. The Zivotofsky and Noel Canning cases, which involved questions about the scope of presidential powers, the first in the realm of foreign affairs and the second with respect to filling vacancies. Then there was the challenges to the Affordable Care Act and the accompanying litigation over the contraception mandate, a challenge to the CFPB and whether it was constitutionally structured under the Dodd-Frank Act, litigation surrounding DACA and DAPA, although that came at the very end of his presidency, And then an array of challenges near the end of his presidency to the Clean Power Plan, the fiduciary rule, his Title IX policies, his policy with respect to transgender students, and the like. So that's an 8-year period of time. That was the list I came up with of the suits that were like a big deal. Now let's talk about President Trump's first year in office. And here's a list of these are the ones that made my cut, okay? We've got the travel ban lawsuits, multiple of them, including multiple Supreme Court opinions already. The travel ban suit challenges to the president's policy of excluding transgender individuals from the military, his threats to defund sanctuary cities and states of access to key and unrelated federal funding, suits for violating the foreign and domestic emoluments clauses, a challenge by the Knight Institute to the president's policy of blocking people from his Twitter account on the basis of their commentary on his position, litigation over the DACA rescission, including claims that he violated the Equal Protection Clause by basing that decision on animus toward the class of undocumented migrants and Hispanics, litigation over whether he properly installed Mick Mulvaney to head the Consumer Finance Litigation Bureau, challenges filed last week to his decision to include a citizenship on the question on the census. That decision was made by Commerce Secretary Ross, litigation challenging his pardon of Sheriff Arpaio, litigation challenging his decision to revoke protected status for Haitian migrants, based in part on the claim that he referred to Haiti as a shithole country and didn't want people from there to enter the United States, and challenges under the Equal Protection Clause on a theory of sex stereotyping to his revocation of Obama-era Title IX guidelines. And that's just like the start. You could go on and on. There's a lot of litigation. And those are the constitutional cases, by and large. Like, those are that's the sort of heavy-hitting federal litigation against Trump administration policy. What I didn't include on that list, and what I won't talk about as much today, is the onslaught of regulatory and administrative law challenges that have prevented the administration from delayed implementation of many regulations that were put in place in the Obama years, in which they have declined to go through the appropriate process of revising. Litigation raising oversight and accountability challenges, most famously to the Kobach Commission, which was essentially created to perpetuate the myth of widespread voter fraud, and which collapsed in acrimony when internal violations of process and procedure were revealed. Private civil litigation against the president, including the now famous Stormy Daniels case, the Zervos defamation suit, challenges alleging that he incited violence at his campaign rallies, unfair competition claims arising from his improper business practices. This is the Cork Wine Bar suit in DC. And then I'll count this in, an array of litigations that involve the president changing position on important issues. So at the Supreme Court, this administration has attacked the CFPB. It has attacked the constitutionality of the Securities and Exchange Commission's method of adjudicating cases. It has gone after the ACLU, which defended women who wanted abortions, juvenile migrants who were in the custody of the Office of Refugee Resettlement and were unable to exercise their right. And it accused the ACLU of ethics violations, and it has most recently sued the state of California for its own sanctuary policies. So here we have an administration that I think it's fair to say is just engulfed in litigation on a scope and a scale unlike anything, certainly in living memory, and my intuition is ever. Why do we think that is? What would explain the emergence of what people have started calling the legal resistance to Trump? I don't think there's a master explanation. I'm not the kind of guy who likes to stand up and tell you that it's all secretly about this one cause that everyone has failed to sufficiently appreciate. So what I'm going to do is just walk through a bunch of related causes that I think together help explain the phenomena that we're seeing of this kind of legal resistance to Trump. And I'll start with one that will sort of give away my own political views, but a widespread perception of President Trump as essentially unconcerned with the requirements of law. And as motivated by an essentially autocratic and bigoted perspective that he has brought to bear in his words as president and his deeds as president. Now, we live in a time where partisan polarization is high, inter-party hostility is high. There was all of the structural forces were in place for fierce combat over whoever took office. I don't think any of us doubt that if Hillary Clinton had won, she too would not have been besieged. Heck, for all we know, she would already be facing impeachment proceedings if the Republicans had managed to take control of the House. So we're in an environment that's sort of a giant powder keg for this kind of partisan legal warfare. Even within that, though, Trump has done little to calm and much to inflame all of those underlying dynamics. And in particular, he's done so by conducting himself in a way that suggests that he is essentially a classic Holmesian bad man. right? This is a guy who wants chalk on his cleats. He wants to walk up right until where Article 2 stops, or where the Equal Protection Clause stops, and he wants to be able to do whatever he wants within that space. We've seen that in his attacks on courts, on the FBI, and on the Department of Justice, which he's apparently unaware he oversees. We've seen it in his attacks on the press, on racial and religious minorities, and really on any institution that threatens his power. We've also seen it in his attacks, his personal attacks, on anyone who criticizes him, on businesses who criticize him or that criticize his businesses. We've seen it in his creation of state TV, with his tweet this morning promoting Sinclair Broadcasting over CNN, and with the fact that he seems to live tweet Fox and Friends on a regular basis, and that appears to have some tremendous explanatory power about what he's up to. And we've seen it in his attacks on racial and religious minorities. And really what that speaks to collectively, I think, is a departure from, in fact, a rejection of norms. So we're not talking about constitutional hardware here. We're talking about constitutional software, but the set of cultures and institutions and understandings that have shaped American perceptions for quite some time and across both political parties of the responsible way in which the President of the United States should exercise power. We've seen his attack on prosecutorial independence, his rejection of anti-nepotism and corruption norms, his rejection of classic norms of free speech, his condemnation, his support of private militias who use violence to terrorize racial minorities, and his attack on businesses for not firing employees who do things that he disagrees with. When you have a situation like that, where the president is rejecting the norms that have long constituted our understanding of how the president should exercise power, the stakes go up in a really big way. Because unlike, for example, in the Obama years, we're not just talking, or even in the Bush years, we're not talking about, say, battles over discrete policy outcomes. The lawyers who are going after Trump aren't motivated solely by concern about a single policy issue. The stake is essentially democracy as such. There's a sense that the Constitution underspecifies, as it were, the limitations on the president, that you would need to have a president who can actually preside over a workable democracy. And norms have filled that space and created and constituted a presidency that can make our democracy work. And President Trump is cutting through those left and right, which has led lawyers to think, and which has led other groups to think, litigation is necessary because the stakes are so high. Because the stakes aren't just a particular policy, but the stakes are a conception of the presidency and the appropriate use of executive power. Or to put it differently, lawyers involved in the resistance are simply not inclined to think that they will stand idly by while Rome burns. Now that may sound a bit hyperbolic, and some of you won't agree with the way I've characterized it, but for what it's worth, I do think as a descriptive matter, a sense of lawlessness emanating through the administration is an important part of the phenomenon we've seen. That is, of course, related to the president's innovative use of Twitter and the public statements he has undertaken to make. Those statements have not only encouraged the perception I've just described, they've also created litigation opportunities where they otherwise may not have existed, or where they may have been a lot more difficult to pursue. So for example, the fact that he called Haiti a shithole country, and then almost immediately thereafter revoked protected status for a large number of Haitian migrants, created an opening for the NAACP to file suit. The travel ban policy is, of course, the classic example of a policy that would have been difficult to defend on its own terms, but which I think they would have prevailed on. And it was really the president's public statements tying the underlying travel ban policy across the various iterations of that policy to anti-Muslim animus and to a perception that Muslims aren't welcome here and we don't want them here. And then you also see it in more mundane matters, like, for example, the AT&T Times Warner merger trial that's currently going on in federal district court, where AT&T has been, it's going to defend on the ground that there isn't an antitrust violation, but they've been able to introduce a major new element to the case, one that gives it a sort of resistancy feel, by arguing that they were targeted by the Department of Justice because the president has publicly expressed disapproval of the companies and of the positions that they and their associates have taken with respect to some of his own decisions. So the president's norm-defying behavior, including his public statements, have created opportunities and desire to litigate on a scale that may not have existed before. And the result of all of these trends is something that Jack Goldsmith has called Libertarian Panic, which is a sense that democracy itself is threatened in a systemic way, and that in some respects overexcites the president's opponent to feel like they need to whack every mole. You need to stop him at every turn, you need to plug every gap, you need to sue for every illegal act, because this is all part of a broader attack on underlying democratic norms. So that would be the sort of first broad explanation I would offer of what's going on here. The second is that the president has largely implemented policy through executive orders, not through legislation. That's one of the reasons why Trump's own statements have become more important. It is, of course, a reflection of broader trends toward congressional dysfunction and gridlock, which we're now seeing not in a period of divided party rule, but where Republicans control 2 and arguably 3 branches of the federal government and have only managed to pass a single major piece of legislation in Trump's first year in office. If you compare that to President Obama's first couple of years, he was not issuing executive orders at anywhere near the clip that President Trump is. He was investing his political capital in legislating, and in particular in TARP, in the Dodd-Frank Act, and in the Affordable Care Act. And when you pass a major piece of legislation like that, it will over time generate lawsuits, very large numbers of them, because it touches so many issues. And indeed, both Dodd-Frank, in the form of creating the CFPB, and Obamacare came under constitutional attack in the later years of the Obama presidency. But whereas legislation takes a longer time to pass, it involves a more comprehensive process, the executive orders, and therefore delays the filing of litigation, which would explain in part why there wasn't a ton of litigation in the first years of the Obama presidency. When you govern by executive order and you fire them fast and furious, and when the executive orders that you're issuing are not conferring rights, as many of President Obama's did, but are rather restricting them, you create irreparable injury, which opens the door to lawsuits seeking preliminary injunctive relief, but you also just create a lot of low-hanging fruits and a lot of target. And so, Trump has passed one major piece of legislation. Like every major bill passed under Obama, it has been attacked on constitutional grounds. A group of states argue that the $10,000 cap on deducting state and local taxation violates state sovereignty with respect to the taxing power, and it will be interesting to see where that goes. That suit is unsurprising in that every major piece of legislation for some time now has come under constitutional attack, and this reflects the broader constitutionalization of policy difference. But under Trump, you haven't just seen the attacks on legislation, you've seen the attacks on executive orders. And when you govern by executive order, you can die by attacks on those policies. That then speaks to a third relevant point, which is those executive orders have not been well crafted. Or stated differently, if you're going to govern by executive order, you need non-morons writing them. And needless to say, that was not the case, at least with respect to President Trump's first travel ban. There were internally contradictory reports from his own Department of Homeland Security. His own advisors made public statements that we have hung around his neck in the litigation. It was issued with essentially no process, no procedure, no announcement. That was a high watermark of a sense of just like things going terribly awry in the administration. But it's emblematic of a broader policy issue in this government, which is it seeks to exercise the executive power without adhering to norms of process and restraint and personnel that have historically guided the administration and prevented some of the things that they're encountering. So, for example, he has refused to submit his potential emoluments to the Office of Legal Counsel for review, as President Obama did. There is now a lack of clarity, incredibly, about whether the president fired his own Secretary of Veteran Affairs, which matters because if he fired him, the Federal Vacancies Reform Act arguably doesn't apply, which will control who can serve as the acting head of that agency until the president is able to confirm a replacement. Or consider Secretary Wilbur Ross's decision to add a question about citizenship to the 2020 census. Part of what we're seeing in the lawsuits that have already been filed are administrative procedure attacks, reflecting the fact that the census is usually the product of carefully tested questions that go through an extensive process. And here, the secretary just jumped past all of that and added it there for blatantly partisan reasons. And I suspect that there will be consequences for that in litigation. The next trend that I think we've seen under this administration that explains what's going on, and I'll just be blunt about it, is that they're acting on the basis of animus. And that instead of backing away when they're called on it and when they lose in court, they dig in their heels more. We see this with the travel ban. We see it with the transgender ban. I think we're going to see it in a lot of other areas. When Trump loses in court, he doesn't walk away. He doesn't say, oh, God, you got me. I did it because I hate that particular group. His executive orders, many of which frankly exist primarily to symbolize the inferiority of targeted groups more than they do to implement any programmatic policy perspective, are then revised. They go through this kind of animus laundering process where one of the relevant agencies like puts a bit of legalese on the animus and like dresses it up nicely and then sends it back into the world, and they say, look, we've revised it. Now it's okay. Now it's clean. Thus far, those arguments have not held up very well. And one of the reasons they haven't is that instead of engaging in the usual empirical research and notice and comment procedures and the usual methods by which you would create this policy, and instead of publicly and expressly disavowing some of the animus that was alleged to animate it, the president has only leaned into the hate. And when that happens, it's going to create both a desire to sue and litigation vulnerabilities. Last but not least, I'll just offer a couple more reasons for why we've seen this kind of legal resistance. The first, to state the obvious, is that there's widespread public disapproval of the president. When the president's public approval ratings are low, when his political enemies are strong and motivated and organized and unified, when there are social movements like the Me Too movement, like the movement now to promote gun reform, like the movement in favor of protecting dreamers, it's easier to motivate suits, to bring suits. Social movements expect that there will be accompanying litigation. And that also buys you a bit of purchase in the courts because you're not showing up as some rando, right? You're showing up as someone who can credibly claim to speak for a major force and momentum within the American political scene. And then last but not least, maybe two more cynical perspectives, Democrats don't control any part of the federal government, which is quite inconvenient when you're trying to block the president from doing illegal things. In the absence of an ability to mount an effective political resistance within the government, what we've seen is a turn to litigation and to courts as fora in which claims that are now associated with the Democrats and the never-Trump conservatives can only really receive a hearing in the halls of power, in the halls of justice. You can't get it in Congress. You can't get it in the executive branch. The courts are the only place you have to turn there, and, of course, the state attorney generals, who have risen as this kind of heroic force on the Democratic side and have exercised powers uniquely available to them as spokespersons for states who have special prerogatives in litigation to seek to enforce constitutional guarantees. So we've seen Democrats lose power in the federal government. We've seen the rise of Democratic litigators at the state level, kind of like what happened under Obama in Texas and West Virginia, except on steroids and then on like more steroids. And we've seen them pursuing their claims in court where they can at least be heard. And last but not least, they've won. It turns out that if you're trying to bring a legal resistance, winning a bunch of cases off the bat is like a real boost. It makes you feel like you have a chance. Now, this is partly because the lower federal courts are currently populated primarily by Obama nominees. And as I'll mention later, I think that ultimately this trend may reverse itself in part because that will change. But the fact that they had a largely friendly audience in the lower courts, the fact that it takes a while to get to the Supreme Court and the administration isn't willing to overextend its capital to try to rush cases there and has lost when they've tried to do so, as recently occurred in the DACA litigation, has not only meant that there's a forum in which claims can be heard, it's a forum in which you can win. And winning, as President Trump has taught us all, is fantastic. Winning is great. And that goes to the question, what are we trying to win? And when I say we, I don't mean like the resistance generally, because I can assure you, we are not well organized. There is not like a mothership where the vast left-wing conspiracy meets. There's sort of a conglomeration of actors who I think are mostly sympathetic to each other's goals and who are all overwhelmed because everything is on fire everywhere, always, all the time. And we're trying to sue for all the illegal things, but there's too many of them. But so when I say we, I mean we, like that group of lawyers. What are the lawsuits trying to achieve? I'm going to put 6 ideas on the table here. First, and it's easy to lose sight of this in an environment where everything is sort of dressed up in big ideological stakes, we're trying to make life better for men and women who are harmed by the president's policies. Article 3 of the Constitution means that you can only bring a claim if you can show that you have suffered a concrete and particularized injury. The lawsuits filing these claims don't wake up in the morning and think like, you know, Trump is terrible. Let me go see if I can just like find someone and gin up a lawsuit so that I can get a good New York Times article out of it and send an email to my donors. There are people in the world who are suffering. I've received phone calls from transgender servicemen in active service who want to know what they can do. I've spoken to people who were directly affected by the travel ban. Many of us have probably had experiences with either those groups or undocumented migrants who now live in fear from a government that seems out to destroy their friends and their family and their lives here. These lawsuits reflect the fact that this administration's policies are causing human suffering, and the suits have been brought to try to abate that. You can't stop it indefinitely. The federal government has a lot of power. The executive branch can revise its policies, it can reissue them, but you can slow and stop and mitigate and try to blunt the worst effects of some of it. And the fact that many of this administration's policies have caused clear, concrete, immediate injury is one of the reasons why we've seen so many grants of preliminary injunctive relief and why the lawsuits have accelerated at the pace that they have. The second thing the lawsuits are trying to achieve is to protect the rule of law and to vindicate values of legality and due process as a systemic good in our society. Like I said earlier, legality as such just appears to have no normative weight whatsoever in the president's mind. I don't think he likes his lawyers, which is fair because I don't like them either. I don't think he likes his lawyers. I don't think he listens to his lawyers. I think his question is, what do I want to do? And how can I do it? And can you all please get out of my way? We saw it in his attacks on his own Department of Justice, his open disregard, and in fact, his repudiation of lawyers made by his arguments in court, and by the fact that he's attacked the judiciary itself, both in direct public criticism and in his pardon of Sheriff Arpaio, which was a clear slap in the face of the court's power to vindicate the principles underlying the Equal Protection Clause in our civil rights law. So the lawsuits exist in part as a reaction to that. This is a country founded on law. No one is above it. The Constitution cannot be clearer on that point. And one of the reasons we've seen this swarm of lawsuits is an effort to vindicate, in the face of what seems like a sort of abyss of lawlessness, a principle, which is that there are certain ways you have to do things. And there are reasons that are not available to you as president when you choose to make policy. And if you cross those lines, you'll suffer a consequence. A third goal, and here I'm going to start stepping backward a bit, is to enforce norms of executive branch behavior and decision-making. Some of the lawsuits seek sort of direct enforcement of norms. And here I'm borrowing a term from Daphne Renan, who has a fabulous article about this coming out in the Harvard Law Review. Some of these suits seek direct enforcement of norms. They're seeking, in other words, to constitutionalize or to statuitize, I don't know, whatever the word is. They're seeking to turn a norm into the law, turn software into hardware. I think the clearest example of this is the Emoluments Clause, where a long-standing norm that the president would comply with a wide array of anti-corruption rules in government is now being given constitutional heft in part. The Emoluments Clause represents the core of the core, right? Like, we think the president should not be engaged in transactions with Vladimir Putin that benefit him. Call us crazy, right? But like, that's sort of the core anti-corruption norm. The framers cared about it so much, they wrote the damn thing into the Constitution, and we're seeking to insist on that, which we wouldn't have had to do in any prior administration, because presidents voluntarily complied with statutory ethics rules well above the floor set by the Emoluments Clause. We also see norm enforcement in the case that I'm working on, challenging the president's appointment of Mick Mulvaney to head the Consumer Finance Protection Bureau. There's a case, we have very good statutory arguments about whether that appointment was permitted by the Dodd-Frank Act, but there's another claim in the litigation, that the CFPB is an independent agency. It literally says so in the first word of the statute creating it. It's an independent agency, and if independent means anything, going back to Humphrey's executor here, right? Dust off your old law books, like we're in 1930s territory, it's very exciting. If independence means anything, it means that the president should not be able to appoint a political official who serves at his pleasure in the White House as the sole director of an independent agency, which is statutorily walled off from influence by the OMB, which that person also runs, right? So when you think about what we're trying to achieve in that case, it's partially we have just a damn good statutory argument, and I hope will prevail on appeal in the DC Circuit. But there's also a broader idea of what agency independence means. But then there's also a kind of indirect norm enforcement lurking behind a lot of the litigation in terms of what it's trying to achieve. Think about the travel ban. Think about the ban on military service by transgender persons. Nothing in the Constitution says that the president needs to ask some of his bureaucrats before he issues an executive order, right? There isn't a rule that like, Mr. President, you have the executive power, but it turns out these like mid-level randos in the Department of Homeland Security get a veto on whether you've exercised it wisely enough. But what there is a long-standing norm and tradition that the president will consult with experts, that he'll consult with lawyers, that he'll talk to people within the executive branch that have created the institutional environment for the prudent and responsible exercise of executive power, and to ensure that his decisions reflect the institutional competence and the adherence to the rule of law, which is what justify presumptions of judicial deference to the executive branch in the first place. And so in these litigations, the courts aren't saying to the president the travel ban is unconstitutional because you didn't follow norms about appropriate decision-making within the executive branch. But they are saying, we're going to take a much harder look at it if you don't. Departures from norms are being used in the litigation to put added pressure. We see this in the transgender military ban, where in the various decisions blocking the first version of it, numerous courts pointed out that the only existing expression of military judgment anywhere in the executive branch was in favor of allowing trans individuals to serve in the military. That there was simply no empirical basis for the president's policy, which, as you all may recall, I recall this very clearly, he tweeted, essentially randomly, right, surprising even his generals, just announcing, like, we will not allow trans individuals to serve in the United States military. He claimed to have consulted with his generals. These generals are nowhere to be found. And apparently there were news reports coming out of the Pentagon. There was like a 9-minute span between one of his tweets and the second. The Pentagon thought we may actually have been about to go to war with North Korea during that period of time. Because the first tweet said, in consultation with my generals, the United States will no longer allow, ellipses, 9 minutes, transgender, individuals to serve in the military in any capacity. Like, not a model of good executive branch decision-making. And when I said before that you want non-morons making your policy, that includes the president. And so when you think about what these litigations are aiming to achieve, it is in part the indirect vindication of norms of executive branch decision-making. 3 more quick thoughts on what they're trying to achieve. They're trying to mark outer limits on the broadest powers of the executive branch and to create some uncertainty about whether they really do go to the end of the earth. So here, think about the challenge to the president's decision to pardon Sheriff Arpaio. If you took constitutional law with Michael Klarman, as I did a few years ago, he would likely have said, and I would have agreed with him unthinkingly, that the pardon clause is essentially an absolute power conferred on the president and that there are no judicially enforceable limitations on it. Sorry, I don't mean to pick you out, Professor. That would have been conventional wisdom at the law school. I mean, it was taught as that's how things are. Now there are lawsuits and law professors and very smart people seeking to articulate limitations on this. And this is happening in a lot of different areas. The administration is contemplating policies that would substantially expand religious religious exemptions to civil rights laws. The administration is contemplating a concealed carry reciprocity law, which would force states to honor concealed carry permits from states that do properly issue them. One of the goals of some of this litigation is to create anxiety in the administration, to indicate you better think about it because you'll be sued, and to draw lines to start articulating limits that may not have previously needed to be thought about. 5th, litigation exists to educate and mobilize public and political support. The Emoluments Clause case, I think, is as clear an example of this as any. When I was in law school, not just 5 years ago, I did not know what an emolument was. In fact, at one point, I was like super diligent. I was a 2L. I was like, I'm going to read the Constitution. Like, it just seems like something I should do at one point in my life. Apparently, I missed a few words. Because a few years later, when Larry called me and said, hey, there's this thing about the Emoluments Clause. I think it's going to be big. It turns out he was right. I said, that's not a thing, and I don't believe you. And he said, no, like, really, you need to look up the Constitution. It's there, I promise. And now here we are today litigating claims in federal court. Everyone, like I come from a family of doctors who not only don't follow law, they affirmatively hate law. In fact, the day I graduated from Harvard Law School, my mom came up to me and said, and I'm not joking, if you ever decide you want to go to medical school, I just want you to know that we'll pay for it. Right? Like, that's where I'm coming from. Like, I grew up, I was in law school, and I would go home, and it would be like the Passover Day massacre of just like, let's talk about malpractice liability, which I did not want to talk about and which I don't care about. Now I go home, and they're like, have you heard about these emoluments? Like, they're a big deal. Do you know anything about this? And I'm like, in fact, I do. And, we succeeded in making emoluments a household name, household word. And, litigation was an important part of that. If you're just writing op-eds, if you're just talking about it on MSNBC, you don't have the same focal point, you don't have the same focusing effect, journalists care less, the public cares less. We didn't bring the suit primarily for that purpose. We brought the suit because he's violating the Constitution and he should stop. And there are many things to be scared about the manner in which he's violating the Constitution. But one of the incidental benefits of that lawsuit and so many others is to educate the public about the illegality of the administration's conduct, to introduce it to the norms that may previously have been the stuff of executive branch insiders, and to explain why it matters. To explain why it matters in a way that people get. that resonates with them. And Americans love nothing more than a good lawsuit, and so it turns out that that's a useful way to do that. And last but not least, and this kind of relates to something I said earlier, one of the goals of a lot of these lawsuits is to encourage a different political calculus within the administration. If they think that they can act without being held accountable, if they think they can exercise power and the ACLU or the NAACP is not going to show up in court and ask them whether they were allowed to exercise it that way, God only knows what these people would do. Can you imagine if the travel ban had come out and like nothing happened? Like every lawyer was like, I'm taking a break for a few weeks, call me later. It would have been a disaster. It would have encouraged exactly the worst habits and the worst predilections in an administration, because when you're dealing with an administration that functions as a Holmesian bad man, if it wants chalk on its cleats, you need to be standing on the sidelines, right? And you need to be actively resisting every incursion. So this raises a question, okay? So we now, I think, have an understanding of why these lawsuits have been filed and what they're trying to achieve. How have courts handled this situation? President Trump and his and some others have attacked the courts, particularly in relation to the travel ban, but also in relation to many other issues. They describe it as a judicial resistance, which they inconveniently never bothered to define or to separate from what conservative judges did under President Obama. They describe courts as either engaged in rank lawlessness or engaged in nothing more than partisan hackery. And the suggestion is that they've created essentially a Donald Trump exception to the rule of law, and that courts will just like go bananas. Like if Trump is on the case caption, precedent falls by the wayside, and there's nothing more than what Josh Blackman, one of the lead advocates of this view, calls a, quote, thinly veiled legal revolt. Now, of course, that's the extreme version of a different kind of claim, which is that courts are breaking their own norms. And this is a claim I'll impute, again, to Professor Jack Goldsmith, who's warns, in his view, that one of the great dangers of the Trump era is not just that the administration will violate norms, but that those seeking to constrain him will believe that any means justify the ends of stopping him and will destroy many of the norms that they're trying to protect, including norms of fair judicial process. Unlike the first argument about a judicial resistance, that is a good argument. That's a real concern. It's something that anyone engaged in this project needs to think hard about. Ultimately, though, I'm just not convinced that that concern has yet come to pass, partly because I think courts can actually play an important role in vindicating norms within the executive branch, and that it is an appropriate exercise of judicial power to do so, partly because I think this Supreme Court is likely to keep things on a fairly even keel, given its current composition, and partly because at this historical moment, if we're going to err in a direction, I don't think erring in favor of restraining the executive branch is like the biggest mistake in world history. I think we'll make it through. But there's also a sort of deeper reason why I'm unsympathetic to that critique, and it's that I think courts aren't engaged in a legal resistance. I think they're doing their jobs in highly unusual circumstances, right? And it's one thing to say that you disagree with a judicial opinion. It's quite another to say, as some of these individuals say, that courts are abandoning the rule of law, or that they're doing something qualitatively different than what they do in any other instance of constitutional adjudication. And no more than the Steele-Sheezer case reflected a Truman exception to the Constitution, or Ex parte Merryman reflected a Lincoln exception to the Constitution, do I think that these rulings reflect a Trump exception to the Constitution. We live in strange times. The president is violating norms that have previously avoided the need for courts to adjudicate certain issues. He's exercising his power in new and peculiar ways and making unusual statements while doing so. And while I do think that the broader context has affected the way courts have thought about these issues, I'm not here to argue that like courts are all, computers just doing their thing and everything is hokey-dory. I do think courts care about the broader context. I do think it has in some respects, in some cases, probably affected their perspective on what's happening and whether they will defer to the executive branch. But that too is a normal part of the judicial process. And the suggestion that it's a norm-violating behavior by the courts seems to me at odds with how we've long understood how courts function, and frankly with how even conservatives themselves described the appropriate role of courts under the Obama administration, when the double for-cause removal protection provision in the Public Company Accounting Oversight Board was dressed up as the greatest threat to liberty since the War for Revolution. And if on both sides you're going to have this kind of rhetoric, but there is a long tradition of courts accounting for broader context and of sort of tuning their measure of deference to the executive branch, to the executive branch's own conduct. And I think that's what we're seeing. And, query whether they're calibrating it correctly. The idea that they should be engaged in that practice, I think, just flies in the face of how courts have always acted and how they should act. And there underlying this is a sort of deep concern, which is that this kind of resistance policing or resistance shaming, although often presented as an even-keeled, objective analysis, of how Trump is acting lawfully and courts are all acting illegitimately, or how the lawyers that are suing him are nothing but partisan hacks. Although presented objected, it has a way of resolving all legal and factual ambiguity in favor of the president in a way that kind of blurs the distinction between analysis and advocacy. It's one thing to say that the president's travel ban should be upheld. It's another to say that it should obviously be upheld, that it's illegitimate not to, and that the only explanation for why a person would think otherwise is that they're motivated by something that's improper. And when that becomes the manner in which conservatives talk about courts, and which Trump has actively himself encouraged, it functions as a politics of judicial delegitimization, right? And of a sort of an effort to make enforcing the rule of law nothing more than the very same political hackery that I think in some respects the administration itself is engaged in. And the ultimate goal, of course, is to make the courts an ineffective check on the president. If courts are perceived as political, if they're described as political, if the president attacks them that way, it may make them more careful and more cautious about actually enforcing the Constitution in ways that aren't desirable. It may encourage a public perception that there's that the rule of law has no independent force and that it really is just a power play. And ultimately, I think in a time of declining public faith in governmental institutions, the notion that the executive branch would set about trying to tank one of the last remaining ones that people trust is a sign of the underlying irresponsibility that infects so much of the president's outlook on these issues. So again, that's not to say that these concerns are unfair to raise. There are accusations of bad faith on both sides. Accusations of hypocrisy are easy to come by. I remember during the Obama years when some liberals would say very similar things about Republican lawyers and Republican-appointed judges. But I do think that there's something different now than there was then, which is the scale and the size and the scope of it. The fact that it's led by the president himself, which President Obama, like many of his predecessors, would never have done. And also by the fact that it's very clear that our democracy writ large is in a tough position. And it's one thing to make these kinds of claims and to go after the courts in a time of, call it, regular democratic practice. But in this moment, it seems uniquely destructive and uniquely irresponsible to suggest that filing lawsuits and prevailing on lawsuits to enforce the Constitution is nothing more than rank politics and that there's nothing more to it. So looking ahead, I'll close with just a couple last thoughts. There is a concern here about encouraging a perception that Trump will be sued for everything he says and everything he does, and that he'll be denied his constitutionally vested capacity to run the executive branch, which he has. He's the president. He does, in fact, have these powers, and legitimately so, unless proven otherwise. And, especially when the claims against him are that his motives are so impure that he can't be trusted to exercise executive power without judicial superintendence, there is a concern that courts will eventually just burn out, that they're not going to be willing to do it, that they'll feel that their institutional capital is depleted, that their temperamental willingness to engage in this kind of litigation runs short, that national injunctions are an improper way to manage these kinds of cases, and especially as the courts tilt increasingly conservative with President Trump's appointees, who are an exceptionally conservative group, the possibility of going to court and getting this kind of relief will probably start to diminish. And needless to say, that's especially the case if there's a change of membership at the Supreme Court. For that reason, among many others, we need to be careful about magical thinking, about law and lawyers, and about their capacity to deal with the problems that are currently confronting our society. There's a notion abroad in the land that the legal resistance to Trump will save us all, right? That these are tough times, things are going awry in ways that we feel powerless to do something about, and at least the lawyers are out there on the front lines fighting. It's a species of the same fantastical thinking that leads people to think that a Mueller miracle will somehow save us all from this administration. It won't. Even if he finds something terrible, the aftermath of that would itself be extraordinary and extremely difficult for our democratic society. This overinflation of the capacity of lawyers and legal process is something I want to conclude by warning against, as I've been doing, which is that these suits can achieve a number of the goals that I talked about. They can obtain some limited redress. They can stop particular policies from going into effect. They can hopefully encourage norms of good decision-making and can chill political actors who are inclined to use their power in irresponsible ways. But ultimately, they are insufficient. The legal resistance to Trump will not succeed in all of the things that people may hope it will. In fact, I suspect it will fail in many of them. And that just speaks to the importance of the fact that underlying all of this is the fact that we're a democracy. You know, the question of who wins the midterm elections in 2018 and who wins the presidential election in 2020 will have a lot more to do with the future of our country than whether a few more preliminary injunctions are granted or denied. And so while I think the legal resistance as writ large is exceptionally important, and while I think it has done a lot of good and will continue to do a lot of good for all of the reasons I've talked about, I also think it's important that especially as lawyers and as law students and as people engaged in this field, we maintain a degree of realism and a degree of perspective on how much good it can ultimately do and how it relates to the broader politics and social movements that are currently afoot in the country. You know, we need to be out there on the front lines, but ultimately, law will not save our democracy. It can only play a role in that process. Thank you. And I'd be happy to take questions. I'm told we have 12 minutes and not a minute more. Less. We have 9 minutes and 30 seconds. I've answered all your questions. Wow, that was really good. Professor Klarman.
So I'm glad you got to this at the end, because the whole time you were talking, I wanted to ask a question about the connection between legal resistance and political resistance. So if you think the only thing that matters are elections, which is increasingly what I'm coming to the conclusion, that if Democrats don't take control of the House in 2018, we're not going to have the same sort of democracy that we've had for the last 200 years, and certainly if Democrats don't win the election in 2020. I'm wondering if that informs anything else about the litigation. So would it be an argument for focusing more on lawsuits that have to do with voting and gerrymandering, forcing Scott Walker to hold elections, the Pennsylvania state gerrymandering case, which makes me wonder why those suits aren't underway everywhere where there's a Democratic Supreme Court, which I think there is in North Carolina. Maybe you'll tell me there is such a lawsuit there. But that's
I will not. I don't know.
I mean, if you had a couple of those lawsuits in Ohio, Pennsylvania, and North Carolina, I think the Democrats would pick up the number of seats they need almost just from, you know, those in a couple more states. So does this play any role in the calculations about what to litigate? If you think politics matters so much, maybe you focus on certain sort of litigation.
So, on the one hand, I agree, and in fact, you know, I think we're on the same page that, you know, the midterms, the political process are ultimately a major part of it. And especially in thinking about the state of our democracy. You know, politics are going to do a lot more for that than lawsuits. And the lawsuits that are likely to do a lot for it are the kind of law of democracy lawsuits. The gerrymandering cases, the redistricting cases, the election-related cases, and all that. Fortunately, there is not a lack of litigation. And so we don't really have to choose. I mean, by we, again, I mean like not like we're all on like some central planning committee. But all of the lawsuits appear to be happening, right? And so those cases are being brought. You know, Mark Elias and others, you know, the Eric Holder's group. There's been a ton of energy focused on battling over the ground rules of democracy. I mean, we see this in the census litigation too, in the partisan gerrymandering cases that the Supreme Court heard. So there is a fight underway about the democratic process. That's super important because, I mean, it's a shame. It's a shame in the sense that one party has committed itself to a view that inclines them strongly toward repressing the vote. That litigation will matter a great deal, especially if it affects outcomes. I don't think, however, I mean, you say you're gravitating to the view that politics are all that matter. You know, call it rearranging deck chairs on the Titanic. But in the interim, a lot of other people are suffering a lot of harm that really matters to them today, not 5 years from now, not in a way that will be cured necessarily by the next election. And so as much as I think it's important to focus on the politics, you know, there is a kind of role specialization thing. And so like the role I'm in is lawyer, not democratic political operative. You know, and what I see are people being injured by the president breaking the law, and I want to do something about it. And you know, certainly in some cases there's an awareness that these things relate to ongoing political efforts and to broader social movements, and you'd be crazy not to account for that and not to think about it. But that can't be the sole criteria by which you decide which litigation is worth filing.
With that, I think the professor who's teaching the next class is here, so we'll have to end.
Oh,
But I think
oh my
Joshua
gosh.
is willing to stand
I am.
aside and take questions.
Yeah, come say hi.
Thank you so much.